Namaskar, Dilip Singh Advocate. Welcome to my channel, Journey of Constitution of India. Let me share a very interesting anecdote that on 26th November 1949, our constitution was adopted, and a member of the Constituent Assembly criticized the constitution, saying that he wanted to hear the music of Veena and Sitar, whereas what he got is the music of British band. While mentioning this criticism, Justice Rohinton Nariman in one of his lectures very rightly said that the criticism was wrong. And what was what in fact it was, Constitution in fact is a symphony of India played by leading members of British and USA orchestra. And I'm sure you will agree with me that Article 15, 16, 17 and 18 in Part 3 of Indian Constitution are the good music of Symphony of India. We will discuss in this video today Article 18, Abolition of Titles. Generally, a student of law wonders why this is placed in Part 3 of the Constitution with fundamental rights, whereas it does not guarantee any fundamental right. Let us explore the answer. During the British rule, nationalists were having very serious complaint against the British that they were using this conferring of titles as they were misusing the conferring of titles for polluting the mind and polluting the public life. And some of the Indians, to be in the good book of British, used to work against the nationalist movement. So the nationalists wanted to make a provision in the constitution to prevent the state from conferring any title or abuse any such title, And it was an unanimous understanding among the members that in a democracy, it should not create titles and titular glories, and it will go against the realization of social equality. Though it has been placed in the Part 3 of Constitution as an extension of right to equality, Article 18 does not secure any fundamental right, and it imposes restrictions on state, on executive and or restrictions on executive and legislative power of the state. That is why it is placed in Article 14, because conferring of titles is against the fundamental principle of equality guaranteed by Article 14. There are 4 clauses of Article 18. The first clause says no title not being a military or academic distinction shall be conferred by the state. Then what is title here? A title is something, a tag, which hangs with one's name as an appendage, either as a prefix or suffix. For example, you can see that it is Sir, Nawab, Maharaja, Rai Bahadur, as it was used to be given by the British government. Clause 1 prohibits state from conferring any title on anybody. It is a command to the state. There are 2 exceptions only. First, military, and second, academic distinction. It means that a university can give title or honor on a merit of on a man for his merit. Article 2 is again in very simple language says no citizen of a state shall accept any title from any foreign state. There are 2 catch points here. First, it is a command on a state, and second, it is on a citizen. First, it is a command to a citizen, and second, it prohibits the citizen from taking anything from the foreign state. Clause 1 and 2 are of a very general nature, whereas Clause 3 and Clause 4 are of very specific nature, and which prohibits a person from accepting anything from the foreign government while he was he was holding any office or profit or trust under the state. The only exception is that it can be taken by the person after the taking consent from the president. So let us see the text of Article 13 and what is its specification. Then there are 4 catch points in Article 18, Clause 3. First, especially for non-citizen, and non-citizen word is used here. Secondly, it is only for the period while that person is holding the office of profit or trust under the state. Third, taking that title from any foreign state. And fourth, without consent of the president. Similarly, Article 18, Clause 4 has three main points. First, it is the word person is used here. So, citizen, it includes citizen or non-citizen. Second, prohibited from accepting any present or emolument or office of any kind. So, it is not title here. It is something different from what it is in clause 3. And third, it can be accepted after the permission from the consent of the president. So clause 3 and 4 has been added to ensure a non-citizen should remain loyal to the state while he is holding the office of the state, and he should not commit any breach of trust reposed in him. In 1954, the government of India introduced 4 awards: Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri for exceptional and distinguished services in any field including public service. However, it was opposed by many persons. Acharya Kripalani strongly protested against award of such decoration, and ultimately he succeeded when the Janata government was formed in 1977. So these were abolished in 1977. But again it was reinstated in 1980 when the Congress government came to power. On opposition of its reintroduction, it was said by the government that it does not prohibit under Article 18, it is not prohibited under Article 18, and it is merely a state recognition of good work by a citizen in the various fields of activity. There is a very landmark judgment of Supreme Court in Balaji Raghavan versus Union of India, AIR 1996, Supreme Court 770. In this case, petitioner challenged the conferment of award on the ground that it is violative of Article 18, Clause 1. It was argued that the word title should be given the widest possible meaning and amplitude in order to give effect of the legislative intent which was enshrined in Article 18, Clause 1. And it was further said that only 2 exceptions are there: military and academic justices. There cannot be anything other which can be given adjusted under these exceptions. The government came with mainly 3 arguments. First, it said that it is not prohibited by Article 18. Second, the government said that the said national awards are not titles. They are not titles of nobility, and they are not to be used as suffix and prefix, and they are only the recognition of the public service. Further, it also argued that almost every country in the world has this kind of practice of conferring awards and to the meritorious services rendered by its citizens. Then the court observed that during British rule, it used to be abused. The power of conferring titles was being abused by the British for the British interest, and used to be corrupting the public life. So, what in the present context, the court observed that what is the difficulty that government has no guidelines for these awards. No foolproof method of selection is there. So, it is bound to breed nepotism, favoritism and patronages and even corruption. Thus, what is required is a high standard should be prescribed for those awards, and the total number of such awards should not exceed 50 in 1 year. And Justice Ahmadi was very particularly, and he said that the exercise of such restraint is absolutely necessary to safeguard the importance of these awards. They were very apprehensive about the misuse of this power and using this award for any other purposes. The court suggested that there must be a high-level committee which should be appointed by the Prime Minister in consultation with the President who will ensure that only deserving persons are being given this kind of decoration. Justice Kuldeep Singh, who was also in the bench, he wrote a separate but concurring judgment and suggested that the committee appointed, as per the suggestion given above, may include the Speaker of Lok Sabha, Chief Justice of India, as well as leader of opposition in the Lok Sabha. However, the Supreme Court upheld the validity of civilian honors but criticized the government for not framing proper guidelines, so no restraint on the government of giving these awards. It is held that national awards are not meant to be used as titles, and even went to the extent saying that if any person who has been awarded and using this as a title, or he must be forfeited, the award must be forfeited and should be forfeited from him. The situation started changing after the Supreme Court judgment. Union government appointed a high-level review committee chaired by the Vice President, and it was entrusted with the work to go into the existing guidelines and prefixing up the criteria for selection of persons for Padma Awards, so that it would enhance the respect of these awards in the eyes of public. The committee suggested for setting up a state-level committee first, for forwarding the recommendations from the state to the center, and then at the center, these recommendations will be considered by a secretary level committee, which that committee will include cabinet secretary, home secretary, and the secretary to president of India. Thereafter, the finalized name to be submitted to the prime minister's office and then finally sent to the president. The very interesting thing is that these all guidelines and committees were made for only Padma Awards, whereas for Bharat Ratna Awards there is no guidelines, and it is only at the discretion of the executive. Another interesting point I'd like to say here, that even in American Constitution there is a corresponding article which provides similar to the Article 18, which says no title of nobility shall be granted by the United States, and no person holding any office or profit or trust under them shall, without the consent of Congress, accept any present emoluments, office or title of any kind from any king, prince or foreign state. However, even in America there is the civilian awards is there. The highest civilian award is known as the Presidential Medal of Freedom and the Congressional Gold Medal. These are the highest civilian awards in the United States, and these are given to the meritorious contributions to the national interest of United States and world peace, culture, and other significant public or private endeavors. Even in our constitution, we can find an interesting provision in Article 15A, which speaks about the fundamental duties on every citizen. It is expedient there that there should be a system of award and decorations to recognize the excellence in the performance of the duties. So these awards are as a token of such recognitions. At the end, I would like to say that there is a clear distinction between award and title. The purpose of giving award is simply to recognize the exceptional services in public life. So it is not violative of Article 18 or going further, one step further, Article 14. Hope you have enjoyed today's journey with me. There are some important judgments which I would like to discuss later in my video series. Thank you for being with me. Please subscribe to my channel and send your comments about the video so that I can improve in a better way. Thank you very much.